Welcome to the Deep Dive. Today we're tackling a really heavy topic in criminal law, the insanity defense. And we're not just talking about, a clinical diagnosis. We're going deep into the specific legal standard, the Oldham-Natten rule, using a pretty disturbing case, Sanders v. State. Our goal here is to really unpack how a jury has to walk through this element by element, because there's often this huge disconnect, right? You have maybe overwhelming evidence of severe mental illness on one side, and then evidence of calculated criminal actions on the other. How does the law square that circle? When does illness stop mattering for legal responsibility?
That's exactly the tension. And understanding how the Sanders jury landed where they did, well, you have to start with the rule itself. What is the Oldham-Natten standard? Then we'll apply its two parts, step by step, to the facts in Sanders. And finally, look at why the court seemed to prioritize things like running away over what the psychiatrists were saying.
Okay, let's nail down the basics first. When a defendant says, "I was legally insane," what exactly does the jury have to measure that against? What's the test in a state like Mississippi?
Right. So Mississippi uses the Oldham-Natten rule. It's been around since the 1840s, believe it or not, and it basically says someone isn't criminally responsible if, at the time they committed the act, they were operating under a defect of reason because of a disease of the mind. And that defect had to result in one of two specific problems. And these are crucial. They're distinct. One, the person did not understand the nature and quality of their act, like what they were physically doing. Or two, if they did get the physical part, they didn't know the act was wrong. That's about legal or moral wrongfulness, not just, feeling bad about it. It's a cognitive test.
That distinction feels key. Okay, let's put this rule under pressure with the actual case. Let's analyze Sanders v. State. First, what are the essential facts, the ones that really matter legally?
Well, the facts are pretty grim. Back in 1985, Sanders attacked his grandparents, W.D. and Elma Crawford. He shot W.D., then actually bludgeoned him with a hammer he found, and later tried to hide in a trash can. He shot Elma in the bedroom. And here's a detail that became incredibly powerful later. Elma, after being shot, managed to crawl downstairs and wrote "Sanders" on the floor in her own blood. She told the first officer on the scene that Sanders shot them. They also found the phone line pulled out. Elma sadly died about 76 days later from complications.
Wow, writing his name, that's haunting. And the timeline jump, he wasn't caught immediately.
Not even close. He disappeared. Sanders was finally caught in Texas in 2005. That's 20 years later. And records showed he'd been using at least 6 different aliases since about 1990.
20 years on the run, using fake names.
Oh, okay.
So with those facts and the defense obviously pointing to mental illness, what was the specific legal issue when the case went up on appeal?
The core question was pretty focused. Was the jury's decision that Sanders was legally sane finding he didn't meet the Oldham-Natten standard against the overwhelming weight of the evidence? Especially considering, the defense showed he had been diagnosed with schizophrenia or schizoaffective disorder since he was a kid, maybe 8 or 9. One of his own doctors even called him maybe the most mentally ill patient he'd ever treated.
Okay, so a profound history of illness versus these actions. What rule did the appellate court use to analyze this? Can you state the Oldham-Natten rule again, but focus on how the court breaks down those two parts?
Sure. The court applied Oldham-Natten, obviously. Defect of reason, disease of the mind, leading to one of two failures. Element 1, did he understand the nature and quality of the act? Or, element 2, did he know the act was wrong? And the court really stressed, you look at these sequentially, if the answer to number 1 is yes, he did understand the nature and quality, then you basically disregard prong 1 and focus entirely on prong 2, wrongfulness.
Thank you. That sequential part is important. So let's do the court's elemental analysis, step by step, just like the jury was supposed to. How did the court handle the first element, nature and quality of the act?
Well, they dealt with that one pretty quickly. The question was, did Sanders understand he was shooting people, hitting someone with a hammer, and that this would kill them? And the court said, yes, he absolutely did. Even the defense experts agreed on this point. They testified there was, quote, no indication anywhere that he was so delusional he didn't grasp the basic physical reality of what he was doing. So things like hearing voices or being paranoid, while clearly symptoms of his illness, didn't stop him from understanding that part. So the defense didn't satisfy prong 1. He was sane on that element.
Understood. So he knew what he was doing physically. That means the whole case then turned on the second element, knowledge of wrongfulness. What evidence did the defense experts offer to show he didn't know what was wrong?
This is where the defense put all its energy. Dr. McCoy, who had treated him, testified that given Sanders' severe schizoaffective disorder, he believed Sanders did not know right from wrong at the time of the killings. Dr. Webb, another expert, largely agreed. He thought that while Sanders understood the physical act, his intense paranoia at the time meant he couldn't appreciate that his actions were wrong in a legal or moral sense. Essentially, his delusions created a different moral reality for him.
Okay, so strong expert testimony saying his illness prevented him from knowing it was wrong. But clearly, the jury disagreed. What did the state bring forward? What was the evidence of calculation they used to counter the clinical picture?
The state focused entirely on his behavior. Actions, they argued, speak louder than diagnoses, especially when it comes to McKnighton's second prong. They pointed to several things suggesting he knew it was wrong. First, one expert, Dr. Lott, noted that schizoaffective symptoms can wax and wane, meaning he could have had lucid moments where he did understand right and wrong. Second, Sanders himself apparently admitted he wasn't hallucinating when he shot Elma. That's a big admission. Third, the actions right after. Pulling the phone cord, fleeing the scene in the grandparents' car, and the huge one, evading police for 20 years using 6 aliases. The court saw this as extremely strong evidence of a guilty conscience, knowing you did wrong and trying to evade punishment.
That point about the aliases seems, well, it feels like it overshadows decades of documented illness.
Yeah.
How does the law justify saying, okay, he was severely ill, but because he ran, he must have known it was wrong?
From the court's viewpoint, things like flight, concealment, using aliases, these are objective behaviors. They're seen as the most reliable indicators of whether someone knew their actions were wrong at the time. If you know an act is wrong, the thinking goes, your instinct is to cover it up, to escape. The court also looked at the sequence of the attack, the argument with WD first, then killing him, then going after Elma, then disabling the phone. To the court, this suggested planning and calculation, not just a random outburst from a delusion. That 20-year flight became, essentially, proof positive that he appreciated the wrongfulness.
So weighing the expert psychiatric testimony against the objective behavioral evidence, what was the court's final conclusion? Did they overturn the jury's finding of sanity?
No, they didn't. The Mississippi Supreme Court upheld the conviction. They really stressed how much deference appeals courts have to give juries on these incredibly difficult questions of sanity. The reasoning was, the jury heard all the evidence, they were given the correct McKnighton instructions, and they had rational grounds, namely, all that evidence of calculation and flight to conclude Sanders did know his actions were wrong despite his illness. So the verdict wasn't against the weight of the evidence.
It really highlights how narrow the legal definition of insanity is compared to the medical one. Okay, to make this difference stick, let's try those visceral hypotheticals you mentioned. Imagine a guy attacks his neighbor with an axe, but because of a severe mental defect, he genuinely truly believes the neighbor is a giant pumpkin he's carving for Halloween. Which McKnighton element does that hit?
That goes straight to the first element, nature and quality. His delusion is so profound, he doesn't understand the physical reality of his act. He thinks he's cutting a squash, not a person. If the jury believes that delusion was real and controlling at that moment, he'd be legally insane under prong 1. He literally doesn't know what he is doing.
Okay, clear enough. Second scenario, maybe closer to the Sanders situation. The man knows it's his neighbor, knows the axe will kill him, but he believes God, or some external force, has commanded him to do it to, say, prevent the apocalypse. He thinks the act is necessary. Even morally right. Which element now?
Now you're squarely in the second element, knowledge of wrongfulness. He understands the nature and quality perfectly kill neighbor with axe. But, the argument goes, his mental disease prevents him from appreciating that society considers this act legally and morally wrong. His delusion provides a different, overriding moral justification. This is the more frequent type of insanity defense, and like we saw in Sanders, it's much harder to win, especially if there's any evidence suggesting he knew society would punish him, like hiding the axe later. That act of hiding implies he knew it was wrong in the eyes of the law. Okay, so for anyone listening, maybe facing an exam question or just trying to analyze these cases, here's a kind of checklist based on McKnighton, thinking like the Sanders court. Step 1, rule check. Confirm you're using McKnighton. Key terms: defective reason, disease of mind. Step 2, prong 1 check. Nature quality. Did the person understand the basic physical reality, what they were doing, who they were doing it to? Look for really profound reality-bending delusions about identity or objects. If yes, they understood, move on. Step 3, prong 2 check, wrongfulness. This is usually the main event. Did they know the act was wrong, legally and morally? And crucially, look for objective evidence that says yes. Did they flee? Hide evidence, use aliases, plan ahead, confess in a way that shows guilt. Often, that kind of behavioral evidence of calculation or a guilty conscience will outweigh even strong expert testimony about the defendant's internal mental state.
So the big takeaway here seems to be, Clinical illness, no matter how severe, just isn't the same thing as legal insanity under Knighton. The system seems built to defer to objective actions. Flight, concealment, those cold, hard facts often carry the day for the prosecution.
Absolutely. And it leaves us with this really difficult question, doesn't it? The law struggles to get inside someone's head, so it relies on what it can see, the behavior. So here's something for you to think about. If someone like Sanders understood his actions were wrong enough to hide for 20 years, does that knowledge, even if mixed with severe paranoia and illness, make him legally responsible? Does that brief or maybe sustained grasp of wrongfulness negate the underlying disease in the eyes of the law? It really makes you question if a legal test from 1843 is equipped to handle the complexities of mental illness as we understand it today, especially when the stakes are this high.